Okay, I think we're ready to get started. Good morning or good afternoon, depending on where you're joining us from today. My name is Brian Lamb, and I'm the practice group leader for the business litigation group at Thompson Hine. I focus my practice on ERISA litigation, and I reside in the Cleveland office. Thank you for joining us at today's webinar. My co-panelist today is Melanie Lazor, an associate in our Cincinnati office. Melanie also focuses her practice on ERISA litigation, and truth be told, she is the brains of this operation. So you'll enjoy hearing from Melanie today. Today we're going to cover three different aspects of ERISA litigation that focus on defined benefit plans, defined contribution plans, and health and welfare plans. This webinar is the final one in a series of 4 webinars offered by our employee benefits group during the month of October. They saved the best one for last on ERISA litigation. And Melanie and I both think everyone should spend some quality time with litigators every once in a while. Today's webinar is being recorded, and you will receive an email with the recording so you can play it back over and over again later at your leisure. All registrants will receive the recording about 2 business days after today. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer the easy questions during the webinar as time permits. Hard ones we reserve the right to punt on. And with that, we will begin today's program. We will provide a code at the very end of the program that you will need if you are applying for CLE. That gives some incentive to stay awake during the presentation. And with that, we will start. Melanie's going to start us off with a litigation update on defined contribution plans. Take it away, Melanie.
Thanks, Brian. So defined contribution plans, we're starting today with the developments in 401k fee litigation. So lawsuits against 401k sponsors are on the rise. There are allegations ranging from overpaying record keepers, from selecting a share class in a mutual fund that's more expensive than a different share class in that same fund, that the fiduciaries didn't remove underperforming investments, really runs the whole gamut. The key that's been kind of changing recently is that plaintiffs are pursuing smaller and smaller plans. So there's more cases being filed, but we have a lot more decisions that are coming out that are really giving some useful guidance for plan fiduciaries when dealing with these issues. So we're going to be talking about 3 cases today. Each one will help fiduciaries in administering their 401k plans and should litigation be filed in how to handle those. So we'll start with a recent case that the court actually granted summary judgment completely in favor of defendants. And this is a very useful decision in giving a nice roadmap on how a fiduciary can defend a 401k fee case. The allegations here are very similar to what you'll see across a lot of these cases. The plaintiff alleged that the fiduciaries didn't properly monitor the fees being paid to the plan's record keeper, that they overpaid the record keeper, and then that the record keeper's fees weren't properly disclosed because the 408B2 disclosures admitted some indirect compensation received by the record keeper throughout the course of the relationship. The court rejected all of these arguments, though, but to give you some brief background, the real crux of this case by the time it reached summary judgment were that the overall fees paid to the record keeper were too high, but specifically because the record keeper was receiving fees through a brokerage window offered to participants where it would receive its standard fee and expense every time a participant made a trade. And that also the record keeper was receiving fees from the plan's managed account services provider. The managed account services provider, Financial Engines, had a separate contract with AT&T, the plan administrator, to provide these managed account services. And then the record keeper actually had a separate contract with Financial Engines governing the actual access to participant accounts, and so received a fee for that. The plaintiff said that all this indirect compensation should have been disclosed to participants, that overall the record keeper was receiving too high of a fee, and that the fiduciaries did not properly monitor it through a prudent process. So the court rejected all of these theories. The first one on the record-keeping expenses, the court really focused on the process that the fiduciaries engaged in evaluating the record keeper's fees, finding that the defendants presented undisputed evidence that they complied with their ERISA fiduciary duties. Relevant factors that were considered by the court is that the fiduciaries periodically reviewed the 408b2 disclosures, the invoices, and really understood what was being paid to the record keeper during this class period. The record keeper also, or I apologize, the fiduciaries hired Deloitte, an expert, to evaluate the reasonableness of the record keeper's compensation, to consult on the negotiation of a new contract with the record keeper, and really understand where the fees fell in comparison with the market. On top of that, when the contract actually was renegotiated, the fiduciaries obtained an even lower price for their record keeping services than earlier in the class period. So the court looked at all that and said, you've really done a nice thorough process, you understand what's going on, you've gotten input from experts, and you understand that these fees are reasonable in comparison to the market. And then importantly, the court pointed out that the contracts with the record keeper included a most favored customer clause, which ensured that the record keeper's fees wouldn't be more favorable to another plan than it would be to these fiduciaries. So really making sure those fees stayed in check compared to the market at large. Now the plaintiffs went back to this idea that the real issue with the process here was that the fiduciaries did not investigate the indirect compensation that was being received by the record keeper. So from the managed account services provider and from this brokerage window and those fees. And the court rejected this argument, finding that specifically with respect to the financial engines fees, that those data connectivity fees between the record keeper and the managed account services provider are outside of fiduciary control. They're not paid from plan assets, and that those services are governed as part of an independent business arrangement between the record keeper and the managed account services provider. And so this court found that the fiduciary defendants had no duty to investigate that third-party compensation and didn't need to consider it in part of their overall process. So not doing so doesn't make that unreasonable. But that didn't end plaintiffs' claims. There were also claims that the fees to the record keeper amounted to a prohibited transaction because the total compensation received by the record keeper was unreasonable. Some highlights from the court's decision on this were that the plaintiffs just didn't present evidence that the fees were unreasonable. The plaintiffs specifically relied on Form 5500s filed by other companies, showing that the fees paid to the record keeper in those cases were actually lower. One of the plaintiffs' arguments in this case is that the record keeper here was receiving fees for services other than record keeping that weren't really within the fee that was being argued by the court. And the court said no, the Form 5500s are not competent evidence of other companies' record keeping expenses. And also that evidence of what other companies pay on its own, even if it's a lot less, isn't evidence that those other companies' fees are reasonable. And then on top of that, the plaintiff had at times argued that the record keeping fees, which ranged in this case from $20 to $31, that actually fell pretty closely within the range of reasonable fees that the plaintiff had put forward at times in litigation. So the court just really didn't buy the plaintiff's evidence. But the court again fell back on what was actually presented by the defendants. So the defendants were able to present substantial evidence that their fees were reasonable compared with the market. The court looked at the services agreements and the invoices relating to the fees. And really importantly, the court found very persuasive that Deloitte conducted benchmarking against other plans and found that the fees actually paid by the defendant's plan were actually less than other large plans of a similar size, and that the overall financial terms of these agreements were competitive compared to market trends and well aligned with the plan size and complexity. And finally, just in this case, at least, there was a claim relating to the disclosures of the fees that were paid to the record keeper, with the plaintiff arguing that these indirect fees paid to the record keeper for both the brokerage window and for the managed account services access to participant accounts, that they weren't properly disclosed because the specific amount wasn't in those disclosures to participants. And the court also rejected this argument and that found that the defendants had provided a reasonable description of the compensation that had been provided by acknowledging that revenue sharing was paying for part of the brokerage window services, and that there was a formula for how financial engines was paying the record keeper for access to participant accounts. And this was enough in this case. But now switching gears, we'll talk a little bit about what happens when things are a little bit more bittersweet and they go a little bit sideways even after you've gone to trial. And some things to keep in mind specifically on the investment options available to participants, which were no longer really at issue in the last case. But we're moving on to a case against NYU, and yes, this is actually a 403B plan, but fiduciary duties are the same, so we all lump them together in the analysis. But this case went to trial. It was appealed up to the Second Circuit, and the Second Circuit recently issued a decision. The good news, the Second Circuit affirmed pretty much everything that actually made it to trial in this case. So the court at trial had found that the defendants didn't violate their fiduciary duties by not replacing their record keeper more quickly, and they didn't violate their fiduciary duties by not replacing what the plaintiff alleged were underperforming funds more quickly. But the bad news, the Second Circuit remanded and reversed the district court on a dismissal of a claim relating to the share classes. So to give kind of a brief overview on motions to dismiss in the ERISA context, and specifically in these cases that are dealing with the duty of prudence oftentimes, the question ultimately is whether the fiduciary is engaged in a prudent process. It's less outcome-based than anything else. The problem when you're dealing with initial pleadings is the plaintiffs have no idea what the process is, and courts have recognized that and come up with a workaround on how to deal with that. And that's basically that if the plaintiff can plausibly plead that the outcome of the decision was so objectively unreasonable that no other fiduciary would have done it, the court will infer that there was a problem with the process and let the claim proceed beyond the motion to dismiss stage into discovery and potentially later to trial. Now, in the NYU case, the court, the Southern District of New York, had dismissed a share class claim that argued that the plan was offering a share class in the mutual fund, a retail share class that was more expensive than an institutional share class in the same mutual fund. And this is becoming more and more common in claims asserted across the country, because there's no argument here that the investment strategy was different or that there was no reasonable alternative, because in a mutual fund, the investment strategy is the same. So the Second Circuit reversed the Southern District of New York and held that the plaintiffs did in fact plead a valid claim that NYU breached its duty of prudence by offering a retail share class. And there's two interesting issues that were raised by the Second Circuit. The first of which is this mix of funds argument, which is a popular argument in these 401k fee cases, which is basically that when you're looking at a large portfolio of investments, so everything that's offered in the 401k plan, we have to assess that as a whole instead of looking at individual investment options in isolation to see whether there's been some sort of imprudence or to evaluate whether we can infer that there was imprudence. And the Second Circuit said that this is true, but when you're dealing with share classes, you're dealing with a binary choice. There's no kind of question of what other fund would have been offered, what other investment option would have been offered, is it the same? The Second Circuit's saying that you have a higher and a lower cost share class in the same mutual fund. There's really no question here. And that this is enough to get you past the motion to dismiss stage and into discovery to really look at the process. In doing so, the Second Circuit recognized that offering a retail share class is not in itself imprudent, but whether it was more prudent or the process wasn't prudent to offer a less expensive institutional share class is something that should be explored on the merits after the motion to dismiss stage. And the real crux of this decision was that fiduciaries can't shield themselves from liability and discovery just because the imprudence is really only in a small number of funds and not the investment portfolio as a whole. So here, the plaintiffs had alleged that 63 of 103 funds in one plan and 63 of 84 funds in another plan had a cheaper share class available. And this was enough for the Second Circuit to say, we can infer that there was imprudence here. We should let this case go to discovery. Now, the NYU defendants also had a backup argument here, saying, you know, even if this could state a claim for breach of fiduciary duty, the dismissal was ultimately harmless because of findings that were actually made at trial on the other claims. Specifically, NYU said that, okay, so we actually did have a process relating to the share classes. We had a fiduciary committee that followed a deliberative process to determine what investment options to offer. And the Second Circuit, with some dissent from a dissenting opinion, said this isn't enough for us to be comfortable that there was no harm suffered by the plaintiff as a result of the dismissal of the claim, because the absence of a deliberative process is probably enough to demonstrate imprudence on its own, but the presence of a deliberative process alone is not enough to show prudence, because we really need to assess that process and see if it's adequate. See if it was done in good faith, see if it was a quality process that followed appropriate methods to actually investigate the share classes. So the Second Circuit reversed and remanded, and now it's back pending before the Southern District of New York. And finally, and this one is a big one, all things considered, in another motion to dismiss case, but it's Hughes v. Northwestern, or as it's been known to this point, Devane v. Northwestern. And it is a Seventh Circuit decision that was very favorable to fiduciary defendants, where the Supreme Court actually accepted cert. This hearing argument in December, and we're anticipating a decision in the first half of next year. But the basic background of this case, the plaintiffs filed a complaint in the Northern District of Illinois, a very lengthy complaint, several dozen pages, 300 some paragraphs of both factual material and also conclusions of both law and fact, alleging that the Northwestern fiduciaries breached their fiduciary duties in numerous ways, including overpaying their record keeper, offering funds that were too expensive, offering them more expensive share class, allowing their record keeper to engage in revenue sharing. And the Northern District of Illinois dismissed and found that none of these facts allowed the court to infer that there was any sort of problem with the fiduciary process, and dismissed on the basis that it wasn't a plausible story. And so this got appealed to the Seventh Circuit, and the Seventh Circuit affirmed with some key facts were that participants could invest in over 100 options, including low-cost index funds. So the plan didn't need to scour the market for the cheapest possible investment option that the plaintiff may have wanted. So just because a handful of the share classes were retail shares that were more expensive than the institutional share classes doesn't mean that we can infer that there was anything imprudent here. There were other options the plaintiff could have selected. And the court said that inclusion of retail funds does not breach ERISA fiduciary duties, which is consistent across the case law, although its impact on the motion to dismiss stage is a little bit all over the place. And then finally, paying record keeping fees through revenue sharing doesn't violate ERISA. And the Seventh Circuit decision has really been a very strong defense bellwether case nationally, and Brian and I are certainly relying on it in our Seventh Circuit fee case right now. But it is in tension with a few other decisions across the country, specifically in the Third Circuit, and then of course that Second Circuit decision we talked about just now. These cases, they're applying the same basic standard. Is this investment choice so unreasonable that we can infer that there was an imprudent process? But the standard is much higher in the Seventh Circuit than it is in other circuits, and it's the split here between the circuits is becoming more and more clear as more and more motions to dismiss are being decided. So this Supreme Court's decision on Hughes v. Northwestern is going to have a massive impact on 401k fee litigation, on how daring plaintiffs are and what they're going to file and who they're going to file them against. So we're waiting for a decision, but in the meantime, the Department of Labor did file an amicus brief in this case and actually argued that the Seventh Circuit decisions should be reversed because the participants had plausibly alleged that the defendants imprudently offered higher cost investment funds when there were identical share classes that were a lower cost available, and that the defendants failed to reduce record keeping fees. So stay tuned. We should get a decision here in the next couple of months, but until then, fee litigation is largely moving forward. So some takeaways. The standard right now is it's an absolute mess, especially when you're talking about a motion to dismiss and whether you're really going to get into that sticky discovery. So until we have a decision on Hughes v. Northwestern, the chances of winning a motion to dismiss are going to depend on what you're at. If you're in the Seventh Circuit, it's a much higher chance. If you're in the Third Circuit or the Second Circuit, it's going to be very difficult. But regardless, fiduciaries need to make sure to properly document their processes to avoid litigation, and if litigation arises, to make sure that you're prepared to mount a defense. So the decision in the AT&T case is really instructive for what to do and really what to document. But something we didn't discuss today, or that there is a question in that case on who had the fiduciary authority and where had it been delegated. So it's really important to carefully document everyone's roles, their scope of authority, and any fiduciary delegations to keep things nice and clean and make litigation as seamless as possible. It's important to take note of the compensation the record keeper receives from third parties and make sure it's properly disclosed. Yes, the court in the AT&T decision found that there's no duty to investigate this third-party compensation, but it certainly makes the fiduciary process and the prudence of that process all the more strong if that is considered, at least by the fiduciaries in deciding what to pay the record keeper. And also, be prepared to present extensive evidence that fiduciaries acted prudently in monitoring the plan's record-keeping expenses, and make sure that's documented when those decisions are being made. So review the 408B2 disclosures, review the invoices from the record keeper to make sure you understand what fees are actually being paid. Make sure to hire an expert to assist in benchmarking the record-keeping fees. Make sure that you're hiring an expert to assist in making decisions on the investment options and what share classes to be invested in, and monitoring whether investment options are performing according to the benchmarks before you select them. And also, make sure to carefully follow the EBSA's instructions when completing Form 5500 and its schedules. This was certainly an issue in AT&T, but making sure that the compensation that is received by a record keeper is accurately reported on Form 5500s to help avoid misunderstandings on how much is actually being paid. And with that, I will pass on to Brian to give us a discussion on defined benefit plans.
Thank you, Melanie. That was very helpful. I'll just echo that last point you made about the importance of Form 5500s. The plaintiff's lawyers are very sophisticated when it comes to accessing these publicly available documents and scouring them for bad facts or allegedly bad facts, and then comparing and contrasting apples and oranges. So your Form 5500 process should not be on autopilot. You are creating what could become Exhibit A in a class action complaint. So do take care and make sure you've got a good process in place when handling those. Okay, so with that, we will switch to defined benefit plans. These are traditional retirement plans. The thing I want to focus on today is the actuarial assumptions litigation that's going on. These are very big ticket cases, and they are bellwether test cases that, depending how they go, could really affect corporate America. So in these cases, the plaintiffs are challenging the mortality assumptions used by defined benefit plans to calculate alternative forms of benefits. And that is, most defined benefit plans have as their normal form of benefit a single life annuity. That is the life of the participant, the employee. The employee will get a certain amount of money every month until the employee dies. But most plans allow alternative forms of benefit where the participant can convert that single life annuity into, say, a joint and survivor annuity with a spouse, and so that the annuity will be spread out over both of their lifetimes. So the question becomes, what assumptions are being made when converting the single life annuity into an alternate form of benefit, and how do you calculate what that dollar amount should be. The plaintiffs argue that many plans are using outdated mortality tables, resulting in unreasonable and underpayments of benefits in these alternative forms. The buzz phrase is actuarial equivalence. So the plaintiffs are arguing that when you convert from single life annuity to, say, a joint and survivor annuity, what the plan calls for the fiduciaries to do in their calculation is unreasonable, and the assumptions are so bad that you are not having actuarial equivalence between a single life annuity and the joint and survivor annuity. The plaintiffs are pointing to, in the 12 or 13 test cases that are out there, mortality tables baked into the plan documents from 1951, 1971, and the 1980s. Sometimes they're adjusted for a population of male, female, but the basic table begins with the mortality of calculations performed by actuaries decades ago. And these are specified in the plan, so the fiduciaries today are calculating alternative benefits based on what mortality assumptions looked like in America 50, 60 years ago. And the plaintiffs say that that's unreasonable because people are living longer today. A footnote on this, there's another assumption made in performing these calculations, and that is the time value of money. And the interest rates baked into most of these plans range from 5 to 7.5%, which is very high compared to today's interest rates. And the way it works out in these benefit calculations is the defendants argue high interest rates can offset shorter, older life expectancies in older mortality tables. So many of the defendants are arguing no harm, no foul, because even if we had old, outdated mortality tables that assumed people lived shorter lives, that's made up for because we're using interest rates to calculate the time value of money that are way above what today's current interest rates are. So far, that has not proven to be a silver bullet argument for the defense. It hasn't really been ruled on the merits much yet. So the participants affected in these kinds of cases are those who are getting the optional forms of benefits, like a joint and survivor annuity. They also affect participants who take early retirement benefits or late retirement benefits, which also have a calculation that must be performed to get to the actuarial equivalent of what a single life annuity would be at your normal retirement age. Okay, so the whole gist here is you have a default single life annuity at normal retirement age. Plans allow alternatives, but there must be a calculation to figure out what the dollar amount is, and the plaintiffs are challenging the assumptions made in those calculations. So the real sources of uncertainty in these cases, and for corporate America administering these kinds of pension plans, is what lifespan assumptions should we make about our class of participants, and what discount rate should we use to account for the time value of money. These cases in particular focus on lifespans, that is, what mortality assumptions are being used by these plans. So there have been 13 test cases filed so far. The first one was filed in December of 2018. There was 3 or 4 filed quickly on its heels, and it led the defense bar to wonder if we were about to be flooded with these cases challenging the actuarial assumptions of pension plans. And these are big name brand companies that are being sued: Pepsi, MetLife, UPS, just name brand, very large, very traditional benefit plans. The flow of the test cases continued throughout 2019, and then there was a trickle in 2020. The most recent one was filed against Citgo in August of 2021, but it had been the first case filed in about a year. So definitely the pace of these test cases have slowed down, which is why I think of them strategically as test cases. Like the plaintiff's bar is very organized, they're very sophisticated. These are the same plaintiff's lawyers who in prior decades pursued tobacco companies in class actions, or pursued breast implant companies, or pursued the asbestos manufacturers. They have moved on to the dollars held in retirement plans in America, which are in the trillions of dollars. So the plaintiff's lawyers go to where the money is. The money these days is held in 401k plans and defined benefit plans across America. So they are getting smart about fiduciary duties and bringing fiduciary duty claims under ERISA. So the basic theory here is that the fiduciaries of these plans are breaching their fiduciary duty by shortchanging the people who select alternative forms of benefits. I think the plaintiff, these are big cases, and the plaintiff's bar, they only want to invest in the best cases and get some early wins on a test basis, rather than just file hundreds of these and invest the resources on a contingent fee basis. I mean, nobody's paying them an hourly rate, so they can only invest so much. So they focus their investments. Evidence of this is where they have chosen to file their test cases. This is a color map of the U.S. Circuit Courts of Appeal. So Melanie and I sit both in the Sixth Circuit, which is Michigan, Ohio, Kentucky, and Tennessee. You can see the X's mark where plaintiffs have filed these 13 test cases, and they've pretty well covered they've diversified their portfolio as a good ERISA fiduciary would do, and they've spread their cases out into different districts and different circuits, so that if they get a bad ruling in one circuit, it's not necessarily a death knell for their chances in a different circuit. This is a very typical pattern, a very typical strategy that the sophisticated plaintiffs bar make whenever they're bringing new kinds of test cases, not just in the ERISA world, but in any kind of litigation. They like to smartly get some early wins that they can then leverage. So as you can see, the two circuits they have not sued yet are the 10th Circuit and the 6th Circuit. Not that Melanie and I are inviting anyone to file any lawsuits there. These cases are still at the district court level. None of them are on appeal yet at a circuit court. The basic strategy on the defense side and the plaintiff side here, the defendants they always file a motion to dismiss. It's best to nip these cases in the bud before you get any discovery going. Defendants want to win the battle of the experts. Each side hires actuaries who scour the plan and scour the actuarial world, and they take polar opposite views on the reasonableness of the assumptions that are baked into these plans, and they take polar opposite views on whether we have actuarial equivalence between the single life annuity and the alternate forms of benefit. The defendants, and this is a big one, so we're going to talk about this one in a little detail. Defendants want to defeat class certification. Okay, they want to keep these cases to having one or two named plaintiffs suing them about their particular benefits, which are small, rather than have those one or two people have their case converted to a class action where they're suing on behalf of 5,000 or 15,000 class members. If they have to, defendants want to win summary judgment, and we're starting to see some summary judgment files. These cases are maturing enough to the point where discovery is wrapping up in some of them, and you see summary judgment. And at all costs, most of them want to avoid a trial because it's so risky for corporate America. On the plaintiff side, they want to survive all these motions, all these efforts that the defendants make to try to get the case thrown out. They also want to win the battle of the experts. They want to get a class certified. This is their main goal. And then they want to extract a class-based settlement based on the threat of trial. So that's how each side is looking at these test cases. They play out a little differently in each case depending on their facts, but you can see this overall strategy playing out. So how have the defendants done so far on their motions to dismiss? They filed one in all 13 cases. 9 have been denied, either in whole or in material part, the material whole. 3 have been granted on very technical procedural grounds. 1 is still pending, the one against Citgo, the most recently filed case. The rulings so far, even the victories for plaintiff and the victories for defendants, they've been mostly procedural. So for people like Melanie and me, watching and waiting and seeing what we can learn from these cases so that we can then advise our employee benefits colleagues and our clients on what they should be doing. Do they have this similar problem baked into their DB plan? Right now, we're not receiving a lot of substantive guidance in these motion to dismiss rulings. They're very heavily procedural, and that includes the assumption a court must make that all factual allegations pled in a complaint are true for purposes of ruling on a motion to dismiss, and that's very important, but sometimes the allegations are not true. And but you have to get past the motion to dismiss phase before you can fight about that. So the big picture is there really have been no strategic knockout blows on either side. So the litigation continues without any. Here we are, it was filed in December of 18. So here we are almost 3 years later, and we still do not have definitive guidance from these courts about what the rest of corporate America should be doing with their DB plans. On the battle of the experts, it makes my head spin to read through some of the expert reports. I'm not an actuary, so I won't try to regurgitate what they say. Suffice it to say that plaintiffs and defendants, they get their experts who focus in on actuarial equivalence and the reasonableness of the mortality assumptions. Is it reasonable to assume to use a mortality table from 1951? And there's lots of arguments pro and con. In one of the cases, the Huntington Ingalls case, both parties filed dueling Daubert motions to throw out the other side's expert reports as being unreliable and based on junk science. And the federal court reviewed the expert reports and all the briefing and argument and said, actually, I find that both sides' experts have given opinions that are sufficiently reliable to assist the trier of fact. That's the magic language needed to defeat a Daubert motion. So while it was a draw because both sides' experts get to testify at trial, it's really more of a strategic victory for the plaintiffs who can't wait to get to trial in one of these cases because they know that the defendants do not want to go to trial. So, here we are. We're not even getting guidance for clients about what to do at a stage where a case like Huntington Ingalls is on the cusp of trial. Let's spend a moment on the importance of class certification. These are lawyer-driven cases. You can tell Melanie and I are defense lawyers. And these are lawyer-driven cases where the plaintiff's counsel is motivated to get that large contingent fee that you get when you bring a class action. So in any particular participant's claim, their damages are very small. So in one of these cases that settled, where we got to see some of this data, Raytheon, the plaintiff's expert calculated that the average participant's claim was $53 a month. Okay, so in the course of a year, that's $600. In the course of 10 years, that's $6,000. That is not enough money to motivate these plaintiffs' lawyers to file a lawsuit against Raytheon. But in the aggregate here, the total class-wide claims were very high. The same case, same plaintiff's expert in Raytheon calculated the aggregate plan-wide damages if the plaintiff was right, which was disputed, would come out to $150 million. Now the plaintiff's lawyers say, now you're talking, pretty soon you're talking real money. So that is enough to incentivize ERISA class lawyers to bring class actions. Okay, so this, whether a case is certified, can take it from a very small case that's not worth it economically for most lawyers to take on from the plaintiff side to a very big case that becomes a topic of boardroom discussion at the corporate defendant. So what have been the class certification results so far? In the first case where there was any kind of movement in Huntington Ingalls, the parties stipulated to class certification. That is, Huntington Ingalls did not fight class certification. They might have negotiated the scope of it. It's a little hard for me to remember, but they basically said, we're not going to oppose class treatment here. Which is a strategy that can be used in ERISA cases where you only want to have to win your case once, and you want that ruling to be binding on everybody. So that's a valid kind of a strategic decision to make. Here in Huntington Ingalls stipulated to it. In the next two cases chronologically, American Airlines and US Bank, the defendants decided to fight, and they were successful in their fight. And the court denied the plaintiff's motions for class certification. So these cases stayed very small cases with one or two individual participants bringing these very complicated claims. I mean, the expert's report would cost more than whatever the plaintiff could get by way of damage. So the economic incentive goes away for the plaintiffs to pursue these. How did those two defendants win or defeat class certification? It turns on something that's called the winners and losers problem. The plaintiff's experts create these models, and they say, this is how you calculate alternative forms of benefits, and it's unreasonable. And here's how you should do it. You should have used this mortality table, and you should use this interest rate. And they come up with their modeling, and many times they come up with multiple models to say any one of these would have been more reasonable than what you did in your plan. Okay. Now, the problem is the defendants are pointing out that many times in these models, there are winners and losers. That is, the plaintiff's expert is saying, change these assumptions and you get a better outcome for the group. But along the way, some of the participants are worse off under the plaintiff's model, or they're no better off, that they're already receiving actuarial equivalent benefits even under plaintiff's modeling. And so this is a problem in a class certification world, because courts don't want to certify classes where there are winners and losers. The courts only want to certify classes if everybody in the class has the same interest in winning the litigation. And here, some of the class members would want to lose it because they don't want to have their benefits reduced. And the plaintiff's experts have to acknowledge this, and they have done so in some of the cases. Now, this does play out differently depending on whether you have a lot of early retirees and late retirees and how the plan calculates things. But the main thing the defendants are looking for is, are the plaintiffs getting tripped up on the winners and losers problem? Are they really coming up with a scenario that would make things better for every single class member? In litigator speak, what the courts say when you have the winners and loser problem is there's no commonality of interest, therefore we shouldn't certify a class. There's no standing on the part of any class member who already receives actuarial equivalent benefits. They haven't been injured, so no one can bring a claim on their behalf. And that you can't show that a common question pervades the class if some people would be rooting for a win and some would be rooting for a loss. The other prong of what's called the Rule 23B analysis is that this class representative is not an adequate representative of the whole class. Because of this intra-class conflict, some of the relief sought by the named plaintiffs would actually harm some of the class members. So they are not adequate representatives. So that's the main thing the defense world is looking for now in these cases. Would the plaintiff's theories result in the winners and losers problem? There have been settlements in these cases. One thing the plaintiffs do, as they do in all test cases, they settle quickly as soon as they get a hint that the judge doesn't like their case. So in a couple of the cases, the court kind of granted the motion to dismiss, but gave plaintiffs leave to amend to try to fix their problem. But I think the plaintiffs' lawyers looked at that ruling and said, we don't like our chances here. Let's just dismiss the claim. and we'll ride on the other test cases that we have going. Of 9 of the cases have been settled or voluntarily dismissed at this point, 7 on a non-class basis, meaning the defendants presumably paid a very small amount to get out, or they paid nothing. And by the way, that information is usually not publicly disclosed because if it's a non-class settlement. But 2 have settled on a class basis, and the details have to be disclosed to the court and to the class members who have a chance to object. We're going to talk about 2 of those settlements for a second. The main question here is, will there be any trials? So far, every case that's approached trial has miraculously resulted in a settlement on the courthouse steps. The first class settlement, and this does give heartburn to a defense counsel like Melanie and me, in the Raytheon class settlement, the plaintiffs had to submit a motion to the court saying, here's our proposed settlement, and here's why we're settling. They acknowledged that this is a groundbreaking claim. No similar claims have gone to trial. There's no appellate opinions on point on this actuarial equivalence argument. They acknowledge their theories are cutting edge and complex, and that the litigation risks to them are high, and that success would depend on them winning the battle of the experts in a highly technical field. In other words, the plaintiffs are now saying, we're compromising our claim because we face risks. And these are risks that the defendants are also baking into their calculation on how to handle these cases. What Raytheon agreed to do was to amend their plan and recalculate alternative forms of benefits going back 6 years. There were over 10,000 class members. The calculated present value of this recalculation is $59 million. So we're in the, how many figures is that, Melanie? 8 figures, that's a lot of money. For the average pensioner, though, it was $21.40 a month. That would be the increase that they would see. So you can see why a plaintiff lawyer would not pursue a case if these were just individual cases. And there's the kicker: attorney's fees of up to $8.9 million for a case that settled before trial. That's how much money is paid to the class counsel, some of which went right into a war chest to fund the other claims. Huntington Ingalls just announced that rather than go to trial in November, that they have settled on a class basis. So this would be the second class basis. The terms aren't due to be disclosed until Friday, when the plaintiffs have to file a motion with the court disclosing the terms, their plan for giving notice to the class members. This has got to be heartening news for the plaintiffs' counsel. They got extracted another class-based settlement. We don't know if it's as big or even bigger than the than the Raytheon one, but it's still good news morale-wise for the plaintiffs' lawyers. But defense lawyers should not give up, because it is still possible for the sponsors to defeat class certification, like we saw in AT&T and US Bank, and that makes these cases go away. So now all eyes will turn to the remaining 4 test cases: MetLife, Partners Healthcare, AT&T 2, and Citgo. Those are all still in relatively early stages of the litigation, so I don't expect anything earth-shattering here in the next couple months. Strategic takeaways from all this. What should you take away from all this if you do work for a defined benefit plan? 1, the litigation is still inconclusive. We've learned nothing that helps you on the merits. I mean, Melanie and I are having fun watching the litigation unfold, but for employee benefits lawyers and HR professionals, you've learned nothing. It's too early to decide whether to make changes. Let's say you have a 1951 mortality table baked into your plan. Should you change it? Well, we don't know. The courts haven't given us guidance yet. So we remain in watchful waiting mode, where we pay attention to these cases, and we have some advice for clients on things they can be doing behind the scenes. But for the most part, it involves waiting to see how these cases turn out. So with that, I will turn it back over to Melanie to take us home with an update on welfare plan litigation.
Yes, thanks, Brian. Last but certainly not least, we're going to talk about some developments in litigation relating to health and welfare plans, and specifically relating to cross-plan offsetting. So cross-plan offsetting is the practice of when a TPA is withholding in a payment that's indisputably owed to a provider of one plan, by one plan, so we'll call that Plan B, to offset a debt the provider owes for an overpayment on another plan administered by the TPA, so we'll call that Plan A. That's what a recent decision called both plans. And this has started to heat up in recent years. We've had a few decisions that danced around this issue where the plaintiffs alleged that this was a problem. One of the cases, the court determined the plaintiffs didn't have standing. And in one of them, the plaintiffs never asserted a fiduciary duty claim, and the court found it was too late when they tried to do it. But we really haven't gotten any sort of definitive authority on whether cross-plan offsetting violates ERISA. We do have an amicus brief from the Department of Labor that was filed a few years ago where the Department of Labor took the position that out-of-network cross-plan offsetting is a problem and it violates ERISA, but in-network cross-plan offsetting, so where there is a specific contract between the provider and the insurance company to do the work at agreed upon rates. So when you have in-network providers, cross-plan offsetting isn't an issue. It's between the contract between the parties. We finally got a decision this year where court actually faced the question of whether cross-plan offsetting violates ERISA head-on and found that it did. So we're going to the District of New Jersey here, and in this case, a provider alleged that the TPA failed to pay benefits to the provider. The provider had an assignment to pursue these claims under ERISA and violated fiduciary duties under ERISA when it engaged in cross-plan offsetting. And the court agreed and found that when a TPA takes money from a commingled joint account to pay for Plan A's, to pay Plan A for essentially its overpayment, the amount of assets to pay the other plan's claim, so that Plan B claim that the provider is submitting, decreases. So allowing Plan A to recoup its overpayments by reducing payments of actual funds under Plan B, the court found that this violates ERISA both as a prohibited transaction by acting on both sides of the transaction, and also as a breach of the duty of loyalty because the TPA is failing to act exclusively in the interests of Plan B. And of course, there is some tension there because that duty applies to both Plan A and Plan B. The court really didn't address the distinction raised by the Department of Labor between this in-network and out-of-network cross-plan offsetting. But it seems that this provider was out-of-network, although there was a contract with out-of-network providers in this TPA that really wasn't the focus of the decision. But we don't really have any sort of clarity on that distinction yet. But it does seem that the court found that even if both plans allowed cross-plan offsetting, that the TPA still can't circumvent ERISA's requirements. So not a ton of guidance on this yet, but we do know that the court accepted the plaintiff's proposed remedy here, so the provider's remedy to apportion all of that offset amount among the impacted plans. So some takeaways. This is still very unsettled. I mean, we've only had a handful of decisions addressing this, and most of them have ultimately punted on this question. So we really only have one judicial decision and one position taken by the Department of Labor in an amicus brief that this practice violates ERISA. But plan sponsors absolutely need to know if cross-plan offsetting is happening. And if it is, you need to know if it's in-network cross-plan offsetting where there is some gray area still, or if it's out-of-network cross-plan offsetting where both the DOL and the court opinion that we have found violates ERISA. And then once a plan sponsor knows that information, you need to make sure, you need to make a fiduciary decision about whether to allow that practice to continue. And as the theme of this discussion, make sure you're documenting that decision-making process and what decision you actually come to. Should this ultimately be litigated. But some TPAs are offering options. So some TPAs are letting plans opt out of cross-plan offsetting. Some are allowing plans to limit cross-plan offsetting to just in-network providers. And that's something to discuss with your TPA moving forward. And finally, make sure that your SPD is accurately describing what your TPA can and can't do with respect to cross-plan offsetting, so that participants are aware of what's going on.
Great, thanks, Melanie. We do have an easy question in, so that's good news. Going back to Melanie's discussion of 401k, the 401k litigation, defined contribution plans, what do the settlements look like in those cases? On what kind of terms do they settle? So I jotted down a couple notes here. There's two components to the way these 401k cases settle. One is monetary, and the second is a growing trend of non-monetary concessions. So I'll give you a little background on non-monetary concessions in a second. The dollar amount range, and keep in mind, these are all public, this is all part of publicly filed documents, because to settle a case on a class basis in federal court, the parties have to submit the terms to the court in a public filing, and then the terms have to be put to the class members, who then have a vote on whether they want to accept the settlement. So this is coming from the public records. The cases range from $1 million to as much as $50 million, depending on the size of the plan and the class period. Many of the recent settlements have been in the $8 to $15 million range. So we're talking about real exposure. And these tend to be bigger plans with more participants. I mean, that any kind of mistake or conduct, you apply it across more people, and the damage number goes up. But we are talking about real money in these cases. There's real monetary exposure. So it's very important, if you touch a 401k plan, to make sure you're employing a prudent process. The second aspect, and this is troubling to me as a defense lawyer, I do not like this aspect. Some fiduciaries and plan sponsors are agreeing to include some non-monetary concessions in their 401k class settlements. And that includes things like hiring an independent consultant for the plan to give input on the lineup of investment options offered to participants. It can include agreeing to do an RFP every 3 to 5 years for a new record keeper. For those of you who have anything to do with implementing RFPs for 401k plans, people complain about it a lot. It's a lot of work, and the thought of switching record keepers really gives heartburn to a lot of people. But here we have some defendants agreeing to do that on a specified basis, which, by the way, ERISA does not specify that you have to do an RFP every 3 to 5 years. So defendants are agreeing to do things that they're not specifically required by ERISA to do. And some of them, in some of the cases, the defendants agree to provide annual reports to plaintiffs' counsel. I can barely bring myself to say this, that is just like letting the fox into the hen house, reporting to them on what you considered by way of changes to your investment lineup, what kind of responses you got to your RFP, how many people responded, what were the ranges. To me, that's just, it's just planting the seeds for a future lawsuit. And I would tell a defendant to consider paying another $1 million to avoid having to live with these kinds of non-monetary concessions, which can just buy you trouble down the road. So with that, I think, Melanie, unless you have anything else to add, I'll give out the code and finish up here. Okay, great. So if you would like to apply for CLE or HRCI, it must be an HR thing, please note that the attachments are in the handout section in the control panel. So if you look in the upper right or lower right corner, you should see a little box with File, Options, View, Help. There's a handout section there. You can download a PDF of the attorney affirmation form if you're seeking CLE, or a certificate of attendance, and you will need the following code to complete the form. This is what you've all been waiting for. Today's code is capital T as in Thompson, capital H as in Hine. I see what you did there, Melanie. Good one. 1027. So TH 1027, which I guess is October 27th. So that's the code you'll need on to get credit for a CLE or the HR equivalent. T, capital H. Oh, there it is. Thank you, Melanie. TH 1027. Please spend a few moments to complete and submit the feedback form. Melanie and I would love to hear what you thought of this. We do these webinars periodically and we want to get better at them. So please do recognize that we welcome the feedback. So with that, I thank you all for attending our presentation. We will send the recording and the slides to all registrants in a couple days to your email address. If you have questions you are unable to get answered, please reach out to your favorite Thompson Hine attorney. Melanie probably moved up into the top 3 on most of your lists today. If you're not a current client, you contact either Melanie or me or anyone in Thompson Hine's employee benefit group, and we'll discuss options available to address your needs. Again, download those forms in the handout section, use the code TH1027. Thank you so much and enjoy the rest of your day. Thank you.